1. And we're live.
Well, I'm Martin Kretschmer. I'm Professor of Intellectual Property Law at the University of Glasgow and Director of the Create Center. And I'm one of the terrible three behind this network, though most of the credit really should go to Guido and Rosanna. I gave a helping hand, but it falls on me today to say a few words about why we need the network. So why SCOTLIN? Why now? So one of the easy answers is look around you virtually. In Scotland, there's a high density of expertise. And perhaps surprisingly, we don't meet very often. We don't talk very often, even though within an hour, most of us could shake hands in normal times. So in some ways, therefore, this intervention was overdue. We've got the expertise, we've got something to say, but we don't talk to each other as much as we could, and therefore we have also less effect and impact on the environment we live in. A second aspect to why we may need it. So academia exists in a particular space. There's both a need for collaboration, that's part of the intellectual exercise. It's about argument, about reasoning, about the best argument. But there's also competition. So we compete for students, we compete for research funding, and this tension between collaboration and competition is peculiar to the academic world. And if you've got a fast-moving technological environment and policy field in which you interact, it is very important that we find a way of managing this constructively. And our diagnosis as the terrible three is that we should do this through openness. So while often we are most critical to the people we know best, we should not do this here. I think we should support each other in developing an area where we have to develop expertise quickly because the world is changing so fast. So a third observation. So what's the role of Scotland here? One of the peculiarities of this network is, and if the terrible three, we are all immigrants, is what is the role of Scotland as a jurisdiction at the periphery? Does that matter? And in what is the contribution of immigrants? What's the contribution of innovation? And how does the periphery link to the fast-changing technology? So is Scotland looking for a competitive advantage, doing things differently? What are the levers that are possible there? Are we seeking to influence the standards adopted internationally? Are we shaping? Are we players internationally? So these are really important questions, and they're particularly acute now in the post-Brexit environment. So how do we understand ourselves now as a jurisdiction at the European periphery, but one with a intellectual weight? Okay, I think that's really a few ideas really why I felt motivated to become engaged in this enterprise and support Guido and Rosanna in this fantastic idea. And I think we could have nobody but better here today than Hector MacQueen, who in many ways is the godfather of this field in Scotland. I remember when I came to the UK, which is quite a long time ago now, the first IP conference I attended was one which Hector organized in Edinburgh with Hugh Luddy and Robin Jacob. So long may it last. Okay. Thank you for allowing me a few words, and I return to Guido.
Thank you. Thank you. Can you hear me all right? And I'm going to send myself live. It should work in a second. Yes, I think I'm live. Thank you so much, Martin. That was excellent. We're really excited to launch the Scottish Learning Innovation Network today. I think of all the things you said, probably the thing that resonated with me the most was the importance of really tackling silos in terms of research centers, talking to each other, in terms of people with different expertise, talking to each other, and also in terms of academia, going beyond academia and talking and working with legal professions, industry, and civil society. And I think we've done this, really bringing together a diverse group of people. Thanks to the Royal Society of Edinburgh, we are able to support a number of activities and resources. You can see the website. That is www.scotlin.org. That is going to showcase research achievements, publicize events, post educational videos, and so on, but also a mailing list and a newsletter where we can find opportunity and share opportunities for collaboration and knowledge exchange. Scientific activities are really at the heart of what the network is going to do. The first, after the keynote speech that Hector MacQueen is going to give today, the first event is going to be a symposium chaired by Dr. Marta Eliadica, Create, University of Glasgow, about assessing the scope for a distinct Scottish information law, which is probably going to be in September 2021, but obviously it's COVID dependent. We're going to organize annual conferences. The first one will be in Stirling in January 2022 and the second in Aberdeen in January 2023, as well as early career scholar symposiums. The first one will be in Edinburgh, hopefully in the summer of 2022. And every other month we'll have enlightening talks, virtual talks that are coordinated by Rossana Ducato, who's going to tell us more about them very soon. Before giving the floor to Rossana, I would like just to thank everyone who made this possible. First of all, the Royal Society of Edinburgh, including their admin staff and Sacha Carcassonne, our referees, Professor Dame Sue Black and Professor Hector MacQueen, our reviewers, Professor Abby Brown and Dr. Dave McCardle, all the co-founders and steering committee members. I would like to give a shout out to the Centre for Research into Information Surveillance and Privacy, CREATE, and the University of Glasgow, Script, and the University of Aberdeen, the Strathclyde Centre for International Law and Policy, the Centre for Commercial Law, Aberdeen, Dundee Law School, St Andrews School of Computer Science, Aberdeen Law Division, Robert Gordon University, Scottish Society for Computers and Law, Faculty of Advocates, Law Society of Scotland, Codebase, and Open Rights Group Scotland. I would also like to thank our assistant, Ziao Lee, our moderator, Arleta Gurecka, and our learning technologist, Fred Phillips. But obviously, above all, most importantly, my amazing co-investigators and partners in crime, Dr. Rossana Ducato, Aberdeen, and Professor Martin Kretschmer, CREATE and University of Glasgow. And that's all for me. I'm going to give the floor to Rossana Ducato now, who's going to talk about the enlightening talks. Thank you.
Thank you very much. Thank you very much, Guido, also for this great presentation. And I'm really proud to announce the program of our bi-monthly enlightening talks. The latter are a series of webinars on law and innovation run by our SCOTLIN. And I'm going to enlarge the program a bit for you. The goal of the series is to spark the debate on cutting-edge research topics within our community. And by our community, we don't mean only academics and SCOTLIN members, as was already pointed out, but the general public and society at large. Indeed, the ultimate goal, the ultimate aim of these talks is to disseminate our research results with associations, professionals, citizens, and we aim to create a virtuous circle and osmosis between the researchers and the community we serve. You can download the program of the enlightening talks from our website. In a few days, we're going to open the registration for the first of our meetings, starting Thorsten Lauterbach, from Robert Gordon University as a speaker, and Meath Malone, University of Dundee, as a moderator. Okay, and now back to the present. Now it's my pleasure to introduce you the main reason why we are all here today. Professor Hector MacQueen kindly agreed to kick off SCOTLIN's launch event with a keynote speech on law and innovation in Scotland, some impressionistic thoughts. Professor Hector MacQueen is Professor of Private Law at the University of Edinburgh, where he is also the Director of the Centre for Private Law. He is also a Fellow of the Royal Society of Edinburgh and the Chair of the Law Section of the British Academy. Among its most recent publications, I would like to mention a really nice tribute to Ole Lando, published in the American Journal of Comparative Law, and a very relevant piece right now on contract law in Scotland at the time of pandemics. This contribution is part of an impressive international collaborative publication on coronavirus and the law in Europe, which is in open access, so freely available to everyone. Before giving the floor to Professor MacQueen, just few organizational details. After the keynote, we are going to have two Q&A sessions moderated by Arletta Goretzka from the University of Stirling. The first session will be led by some of our SCOTLIN members, and the second session, well, in the second session, we are going to collect questions from the audience. So please use the chat for posting your question. Now, really, without any further ado, it's my pleasure to give the screen to Professor MacQueen.
Your microphone is off, Hector.
Curious how these things do that to you. You're sure you're on. However, we'll not go there. Thank you, Rosanna, for that nice introduction, and thank you again also, and to the other founders of the Scottish Law and Innovation Network. Congratulations to you all for establishing this important innovation in itself. In the last 25 years, Scotland has seen a rising from practically nothing, impressive achievements in the study of intellectual property and the distinct subject of information technology law. Increasingly, the two fields come together in practice, and Scotland should further facilitate this development in academia. It's excellent that the participant institutions come from across the country and from professional as well as academic backgrounds. Scotland's small size means that experts in the fields already know each other, as Martin Kretschmer has said, and interact together informally. The network will enable that, I think, to be deepened in a purposeful and results-driven way. It should enable an effective contribution to the wider networks with which this one will easily connect. I can only express the hope that the initial 2-year grant from the Royal Society of Edinburgh will prove merely the start of funding that will take the network into the long-term achievement that the subject and Scotland really need at this juncture in world affairs. It's also good to see the founders' awareness that these kinds of networks have to operate in a different way in the post-COVID world, and that they have developed plans to deal with this effectively. I look forward immensely to watching the network's progress and contributing to it where I can. Law and innovation as a word pairing tends to connote looking forward into the future. And while this is obviously right and proper, I want to suggest in this keynote address that it is also important not to ignore the past. There is an easy tendency to say that the law is lagging behind the technology and to try and bridge the perceived gap with laws built from the technology. Yet, just as in the words of Oliver Wendell Holmes, I quote, "It's revolting to have no better reason for a rule of law than so it was laid down in the time of Henry IV, for those whose dates on English kings are a bit shaky. That's 1399 to 1413. And I would suggest that we also need a good reason not to use old law to help us with our present difficulties where it can. As Holmes himself, again, well expressed it, in order to know what law is, we must know what it has been and what it tends to become. We must alternately consult history and existing theories of legislation. But the most difficult labor will be to understand the combination of the two into new products at every stage. The substance of the law, Holmes goes on, at any given time pretty nearly corresponds with what is then understood to be convenient. I've thought of myself, that's actually a very good exam or essay question. It's certainly a controversial comment, particularly in the present context. But Holmes goes on, the law's form and machinery and the degree to which it is able to work out desired results depend very much upon its past. Now, I was thinking about this statement when last year I was asked to contribute to a collection of papers on, quote, surprises in intellectual property law for, quote again, senior scholars in the field, by which seemed to be meant those like me who had been around for 4 decades and more. Once I recovered from the shock and indignation of being asked to join such a group and actually begin the writing, I found myself increasingly thinking that the more things change, the more they remain the same. And I think that is a message of some importance for forward thinkers to keep in mind in their work. I hope that this disinterested in the sense of objective observation will mean that an illustrative digression into my personal history will be understood and accepted on this otherwise auspicious occasion. Now, the first surprise for me in IP was to be asked to teach it shortly after I was appointed to a lectureship in law in Edinburgh University in September 1979. When so appointed, I was undertaking a PhD in medieval legal history. That's why I'm up on the dates of English kings of the 14th century. While in current law, I was most interested by contract and its applications in commerce. As an undergraduate, a few years before, I had received 3 lectures on IP from Professor W.A. or Bill Wilson, but had otherwise not gone into the subject at all. However, an invitation from one's head of department, the same Bill Wilson, was not something that I could or should decline. And a key event for me was the publication in 1981 of Bill Cornish's masterly book on intellectual property. Its opening chapter made a powerful impact on me. You could say that my next surprise in IP law was the discovery that it was indeed an intellectual as well as a practical subject. Cornish justified the, quote, rather grandiloquent title of intellectual property thus. At its most serious, he said, this is a branch of the law which protects some of the finer manifestations of human achievement. Moreover, he went on, the subject is growing in importance. This is 1981, remember. Growing in importance to the advanced industrial countries, in particular, as the fund of exploitable ideas becomes more sophisticated, and as their hopes for a successful economic future come to depend increasingly upon their superior corpus of new knowledge and fashionable conceits. There is currently a great deal of political and legal activity designed to assert and strengthen the various types of protection for ideas. No country favors conferring on the creator of an idea a perpetual property in it against imitators. The political and economic implications of such a privilege would be remarkable. Instead, a set of limited forms of protection are fashioned against some types of exploitation by others. And then the really critical sentence, the root issue to which we constantly return is whether the balance achieved by this approach is broadly appropriate to the economic needs of the country and to the prevailing sense of what is just. And that last sentence has essentially informed my approach to IP questions ever since. And I suggest that in its balancing of economic needs on the one hand with a sense of justice on the other, it's also appropriate to SCOTLIN's ambitions. Now, copyright was what my students and I found of the greatest interest amongst the IPRs, especially in its technological aspects. It seemed to have implications and effects everywhere in the world around us. There was also available as a goldmine of information and ideas on the subject, the 1977 report of the Committee on Copyright Law chaired by Mr. Justice Whitford, the Whitford Report, as I'll refer to it from now on. Now, admittedly, the 1970s furore over home taping and commercial piracy of sound recordings, with which Whitford was much concerned, had largely passed the studious me by. But the newly possible home taping of films and broadcast programs by means of video technology was very enthusiastically taken up in my family, while a video rental shop opened up just around the corner from our home and received our custom accordingly. So far as we could tell, the shop did not hire out illicit copies, while we certainly did not copy their legitimate products while we were in possession. Students and neighbours told us, however, that means existed to do the needful should we wish to depart from the paths of righteousness. Nor did we install a TV satellite dish, although many of our neighbours did so to spoil our view, and also, they said, in order to increase further the range of programmes and films available for them to watch and perhaps tape. Now, the copyright legality of much of this home-based activity was by no means clear and would not become so until the passage of the Copyright Designs and Patents Act 1988. In the meantime, there was public debate in which the economic needs of the producers of the copied materials came into heavy conflict with the public's perception of the just use of new consumer-oriented technologies. And the producers didn't always prevail. The most notable example was the failure of the 1988 Act to introduce a blank tape levy. Photocopying was something else again. When I was a student in the 1970s, there was only one photocopier in the law faculty, which students could use to copy articles and case reports. Only the fact that there was a charge per sheet kept our usage down. As a lecturer, however, I soon came across the Australian case, Moorhouse against University of New South Wales, in which the university was held to have authorised infringement by allowing library readers to use a copying machine without giving precise information about the limits to copying under the copyright legislation, and without attempting any supervision to prevent infringement. The degree of indifference was too blatant to escape liability. At much the same time, the University Library in Edinburgh was making wholesale changes to the way in which photocopiers were made available on their premises, involving not only charges, but also form filling and staff supervision, limiting copying to one journal article or a fixed and small percentage of books. A student newspaper asked me to contribute an article on these changes in which I explained their legal justification, including not only the Moorhouse case, but also the Copyright Libraries Regulations 1957, previously completely ignored in the university. I expressed doubt, however, about the fixed percentage rule the library was enforcing, which seemed to me to have no legal basis, and perhaps to run contrary to the statutory rule allowing fair dealing for the purposes of private study and research. Thereupon, in another surprise, I found myself in mostly amicable public debate with the university librarian, although it must be admitted that this debate changed nothing in her libraries. But the discussion was my introduction to how in the real world copyright debates could matter and feelings on the subject run high, especially where the law, fair dealing in this case, was not expressed in quantitative or objectively determinable terms. Going back to Cornish, he also observed in 1981 that while, quote, computer science remains still in its vigorous infancy, far more complex prospects in which computers are linked in networks are beginning to develop. And for this, he drew in the Whitford Report and the US final report of the National Commission on New Technological Uses of Copyright Works, 1978, otherwise known as CONTU, for fairly obvious reasons. Discussing computer databases in which copyright materials and other information were stored for retrieval, Whitford noted a suggestion, quote, "The day may come when all homes and offices throughout the country are linked to a national computer centre via viewer/printer consoles." Conto also commented under the heading "Effects of Future Technological Change," it's now technologically possible to distribute text, graphics and data electronically rather than in traditional printed forms. The limitations and the spread of this mode of distribution at the moment are more in the cost of such technology and in user acceptance rather than in the technology itself. But costs are rapidly decreasing for both storage and transmission. In addition, more and more textual materials appearing ultimately in printed form exist at some stage in the production process in digital form, on tapes and discs or other electronic storage devices. The full text of certain legal materials, such as court decisions, may already be displayed in computer terminals from distant databases. Now, it's certainly possible to see all this exemplified in the Edinburgh Law Faculty as well, from early on in the 1980s through the Lexis database. Like the photocopier before it, the bulky single computer terminal for Lexis was located in its own room in the law libraries. It was more than some staff had. Staff wishing to use the Lexis had to do so, beg your pardon, had to do so through the intermediacy of a library assistant. And this was because every search involved an expensive transatlantic telephone link, and the faculty budget for Lexis was limited. My colleagues and I, spendthrifts that we were, needed mentoring for efficiency's sake. But at least you got to take away your results in the form of a dot matrix printout and continuous form paper bordered in red. I have some of mine still. At the same time, a number of faculty colleagues were acquiring and experimenting with microcomputers, notably the Sinclair QL and the BBC Micro. And that made very immediate the debates about software copyright, which also broke out in the 1980s. The aforementioned Professor Wilson used his machine to produce a computer program entitled "Can John and Mary Marry?", which played "Here Comes the Bride" when the answer to the question turned out to be yes. Others established electronic mail communications between their computers, using dial-up telephone links to do so. By the end of the 80s, however, the university was providing us all with desktop PCs, and in 1990 they began the process of linking all these up in a university network. A sabbatical for me at Cornell Law School in the USA early in 1991 let me see a much more developed network already in operation to receive and send my first emails proper and search on Lexis from my desktop. It would be difficult, however, to say that as a result of all this, the nature and scale of the development of the internet later in the 1990s was no surprise. At Cornell, I heard for the first time about the digital information superhighway, which was apparently just around the corner. What this might mean for society was, however, unclear. Would it be the utopia described in H.G. Wells' Men Like Gods, published 1923, with electronic communication and knowledge available to all, or the dystopian, all-pervasive and ultimately apocalyptic alternative envisioned in E.M. Forster's short story, The Machine Stops, first published in 1909? In some ways, I think both visions have been borne out by the reality. And today, the internet's positive utility has been at least re-emphasized by the continuing communication and activities of all kinds that it's made possible, despite the social and economic lockdowns imposed as a result of the COVID pandemic. Forster's epigraph for Howard's End in 1910, "Only connect," has never seemed so apt a way to survive a crisis. For me, however, the internet arrived in 1995. I noted then in an article that digital technology and the internet posed new issues for copyright, with the process of downloading, which I put in quotation marks, from the system and from databases being, quote, a matter of pushing a few buttons, switches and keys, with the emerging sometimes only in a few seconds. And I'm really not sure how much experience or understanding. Course in 1995-6 for women returning to work after child rearing, during which she was introduced to computers using the new Windows 95 operating system. We each followed her homework program with avidity. Instead of learning by trial and error, as I had been doing, there was systematic, albeit second-hand, instruction. Apart from a much more attractive user interface than anything else I had yet seen, Windows 95 also came with an internet browser, letting you get onto the World Wide Web. And 95 was also the year Amazon and eBay appeared for the first time, prominent amongst the many emerging reasons to try one's hand seriously in this new medium, and to observe in action the phenomenon of dynamic web pages that made online user interaction, and e-commerce feasible. The second event was a 1997 case about copyright and the internet, arising in, of all places, the Shetland Isles off the northern coast of this jurisdiction. The issue was the defender's use on his newspaper website of hyperlinks based on the pursuer newspaper's headlines to reach the relevant pages of the latter's website without going through its front page where the advertising was. Now, the case inspired a special conference on law on the internet hosted by the Edinburgh Law Faculty on 16th October 1997. A tumultuous day was chaired by Lord Roger of Earlsferry, then Lord President of the Scottish Court of Session and a considerable scholar of Roman law. And as he and I walked away together after the final session, he exclaimed enthusiastically, "I never thought there would be so much law in it." It's a very typical remark. Then finally, probably sometime early in 1999, my law faculty colleague Elspeth Reed kindly introduced me to the search engine called Google. Those who've never known anything else cannot realize what an extraordinary difference Google made to a researcher's life. The somewhat cumbrous search techniques which I had learned from the law library's Lexis Assistant were rendered obsolete more or less at a stroke. The ever-expanding world of the internet opened up instead to intuitive searching while I sat at my desk. Further, where before I had usually to get to my feet and walk, perhaps even fly or entrain to and around a library or archive to find things out, now the information was more or less literally at my fingertips whenever I wanted to find it or remind myself what it was. What I didn't realize at the time in my enthusiasm, or for some time afterwards, was that this wonderful technological research tool had huge potential significance, not only for copyright, but also for users' privacy, as the system acquired and used knowledge of their individual details and interests. Now, you may be asking, how does all this relate to SCOTLIN and its mission? The essential point is that the law has been responding to technological innovation for the last 40 years, and indeed for much longer than that. And throughout all that time, commentators have sought to influence the legislators and judges who are ultimately responsible for reworking and reframing the law, albeit with varying degrees of success. In particular, copyright law has remained a constant in that process, and I think that's a very important point. The central ideas remain relevant and in place. But I, at least, do not find the recasting of many of its details over the last 30 years in response to digitization and the internet, striking that balance which Bill Cornish set out, the balance between economic need and general justice. Whitford and Contu both had better ideas and all that back in the 1970s. I've not had the time this evening to make a possible similar argument about the law's protection of individual privacy, but I could have if I had wished to. The further thought I've had in preparing this speech, however, is that many of the technological issues that preoccupied us back in the 1980s, home taping, photocopying, software, for example, have themselves been largely overtaken now, thanks to digitization, internet dissemination, and collective licensing. Those who seek to influence the legislators and judges of tomorrow could do worse, I suggest, than study the successes and the failures of their predecessors in order to help them now with picking their priorities and ways forward. The breadth of knowledge and experience available in SCOTLIN will, I hope, make that task somewhat easier than it was in the past. Let me finish, therefore, by once more wishing all of the participants the best of good fortune in this important project. And thank you all for listening so patiently to my stroll down memory lane. Thank you.
Thank you very much. We're gonna now open the Q&A. First up, we have Arleta Górecka, who's a PhD student at Strathclyde University, but also teaching assistant at University of Stirling. Arleta.
Thank you very much for inviting me for the question. Thank you very much, Professor MacQueen, for this amazing presentation. It was actually lovely to hear how you seen the development of the internet and how you've seen the internet law just creeping into the Scottish jurisdiction. So my first question is, how do you think is going to progress? Is there going to be more emphasis put on the protection of the users on the internet, or whether we're going to actually have a more placement of the innovation processes?
Well, the thing, I have thought about these questions and reflected also that I'm no prophet. My track record is disastrous. But the thing that I think has been important about the last year in particular is just the sheer importance of the internet as a means of people communicating with each other and being able to continue their activities, both professional and more recreational, if you will. There's sometimes a tendency, I think, particularly in legislative circles, if I can put it this way, to see that the internet is everything that's bad. It enables free copying, it enables access to materials for free, and so on. And I think legislators do, the people who possess the ear of the legislators are those whose interests, particularly their economic interests, are damaged by these kinds of activities, or at least they perceive that they are damaged by these kind of activities. The damage is, generally speaking, as far as I can see, not fatal. And what I hope might now be more apparent to legislators and indeed politicians is that this phenomenon is by no means all a bad thing. And it's a very good question, perhaps, to ask yourself, does the good that it does in society outweigh the bad? And in that way, Bill Cornish's balancing act, I think, is more likely to play a reasonable role. It's not just to be assumed that what is for the, as it were, the good of business is necessarily the thing that is best overall for society. So that's the way I would hope it would go. And I can certainly see an argument to be made along those kind of lines in policy circles, and it's one I hope Scotland will pick up.
Thank you. We have now a question from Jade Koulitakis, Abertay University.
Hi, so thank you very much for that presentation. I found it extremely interesting. So my question sort of follows on to what you've previously said, where you spoke about the good and the bad of technology, and you spoke about having to balance, on the one hand, economic interests, and on the other, the sense of justice. And I'm just wondering, we talk about this a lot from a national perspective, but I'm wondering what your views are about how those sort of balancing acts and those perhaps inequalities play out on the international playing field.
Again, there are many strands contained within that very interesting question. Which one shall I pick up and run with? Clearly, there's an issue still about digital access. It is clear, looking at the world at large, that there is inequality, significant inequality in that area, and as a result, the benefits of the internet, digitization, long-distance communication of the kind we're engaging in here, are not accessible to all, but they are more accessible than they ever were. This is the thing that encourages me, and I feel it's highly likely that things will continue to move on, that the technology, mobile technology in particular, will be something that is ever more widely accessible, and that is to be encouraged and supported. Obviously, there is a difficulty there in preventing abuse. One of the big issues I have sensed, and I don't think it requires any particular perceptiveness to see this, is that social media is indeed capable of abuse, and that some people at least may have advantage taken of them in that process, in terms of influencing their ideas, their opinions, and so on. So clearly, and this is difficult because, of course, this is an elite perspective. The balance that Bill Cornish talks about is the sort of thing that people like me always talk about, but it's not always clear why it is that people like Bill Cornish and me and the members of this network should have the ability to tell other people how to think, what to think, and so on. So there is a difficulty, I think, of reconciling liberal principles with genuine democracy, and if you will, if you want to call it populism, then populism, but that's a pejorative phrase. So I think we have to proceed with great caution and care, and avoid at all costs any kind of sense that only an elite which really has all the technical knowledge and so on available to it can actually pronounce. We just have to recognize that a multiplicity of voices is enabled by the technology that we now have, and we have to somehow work with that rather than to try and prevent it or control it.
Thank you. We have another question now from Thorsten Lauterbach, Robert Gordon University.
Thank you very much. And Hector, always good to hear from you. And the first thing that I reflected on at the start of your talk, when you discussed how you got to teach intellectual property law, I started to think about, when I joined RTU, and I had the great ambition to teach copyright law and intellectual property, and I was invited instead to teach contract law and anything but for many years before I got to the Holy Grail, as it were. So that was just a sidestep, perhaps, but more to the point. I think there's always that view that the law is lagging behind, but with regard to innovation, perhaps that lagging behind of the law is perhaps a good thing. It doesn't get in the way. You mentioned a number of examples where the law reacted in haste, perhaps, to tackle perceived injustices, and not to great effect. Is there something to be gained to let the innovators go on, as it were, and only interfere if we really have to?
Yes, very interesting question as well, Thorsten. Thanks very much. I'm just searching in my paper here for that quote from Holmes, and the line that I indicated was, I thought, controversial, but a very good one for essays. The substance of the law at any given time pretty nearly corresponds, so far as it goes, with what is then understood to be convenient. That is a very moot sort of observation, I think, and it's perhaps the answer to the question that you're putting. Perhaps I could just best illustrate that by an example from my time as a Scottish Law Commissioner. And I was working on the law of contract at that particular point in time and proposing reform. And one of the observations that a politician put to me was, well, the people aren't out in the streets rioting about the law of contract, are they? why should we reform the law of contract? It seems to work pretty well. So far as we can tell, no one's society is not falling apart because contract law perhaps has a few flaws from your elite perspective, but no one's telling me about this in letters from my constituents, and so on and so forth. So we have to reckon, I think, especially if we want to influence politicians on what exactly is the political impact that you are trying to address, or of the problem that you are trying to address. And one can come up with inventions and ideas. And I mean, the particular bit of law reform that I did manage, 2 bits of law reform that I did manage to achieve in my time. One was about legal writing, and I was able to explain how useful that would be when people weren't able to get together to sign a document. And actually, the present pandemic has proven that to be absolutely right. Signing in counterparts, which was what the bill introduced, is actually incredibly socially useful. And the other day, I actually did a bit of video execution of an affidavit that I had to give. It wasn't technically the most sophisticated little bit of operation, but I think that was the result of a legal change which the Scottish government introduced by statutory instruments at the beginning of the pandemic last year. Basically, the problem was notarial signing. It has to be in the presence of the notary. Being with the video, being present by video is enough under that particular piece of legislation. So it's also, I think, from that story about finding something that's useful, that is perceptibly useful. I didn't anticipate the pandemic back in 2014 or whenever it was. But my goodness, the utility of having a process by which 2 or more parties can sign the same document when very remote from each other is considerable. So that's the sort of thing that I think provides the answer. You have to find the key, and it's not necessarily to stop rioting in the streets, but it's about doing something that is useful, that people can see the utility of what it is you're proposing.
Thank you very much. We have now a question from Ian Mitchell, QC, Chair of the Scottish Society for Computers and Law, Faculty of Advocates, and a lot of other roles. Ian, the floor is yours.
Hector, it's lovely to hear from you again, and I'm always impressed by the way in which you look back towards what's gone before and see the historical roots of where we're going. And I was particularly impressed by your comments about the balance between, on the one hand, economic and business interests, and on the other hand, society, specifically in the law of copyright. And I am particularly, I'm sure you may know about it, but if not, I commend it to you. There was an extremely important unreported decision of the Court of Session, which actually very much considered that balancing act in the context of copyright. And the case was Hinton against Donaldson, Wood and Murals. And it's an unreported decision of the 28th of July, 1773. What had happened was that the Stationers' Company in England had a monopoly in England of copying and printing of books. And then the Statute of Anne came along, their copyright expired. They had a nice little earner in a biblical commentary published by Mr. Donaldson in Scotland. They had persuaded an English judge there's such a thing as a perpetual copyright in English law, and they had a bash at trying to do the same thing against the unfortunate Mr. Donaldson and claimed they had this perpetual common law copyright in the biblical commentary. Well, we had the great good fortune that one of the counsel who was involved was actually James Boswell, who was Johnson fame. So he actually published a book which gathered together all of the judgments, all I think 15 of them, and that only one copy survives. It's in the Advocates Library. I loaded it up onto Project Gutenberg, which is a wonderful example of open access, and did an article about it in the Journal of on the Free and Open Source Law Review. But just a couple of comments which I think just resonate down the years. Lord Keynes, who was, as you know, one of the giants of the Scottish Enlightenment, said, "In a word, I have no difficulty to maintain that a perpetual monopoly of books would prove more destructive to learning and even to authors than a second eruption of Goths and Vandals. And hence with assurance I infer that a perpetual monopoly is not a branch of the common law or of the law of nature. God planted that law in our hearts for the good of society, and it is too wisely contrived to be in any case productive of mischief." So having won in Scotland that Mr. Donaldson was sued by the publishers in England, and finally in the House of Lords on the basis of the Scottish case succeeded, and that did lead to, and I quote, "great rejoicings in Edinburgh upon victory over literary property, bonfires and illuminations, ordered though by a mob, with a drum and 2 fifes." So perhaps, you know, people do actually riot in the streets in Edinburgh over things matters of intellectual property. Sorry, it was an observation, but I wonder if you knew of that.
Yeah, no, I'm familiar with the case, and what you and I should do after this meeting is over, Ian, is exchange our articles. I didn't know about your article on it. I've got one too, so we can swap them and see what we think of each other's opinion. It is a fascinating case, and I mean, obviously, I spoke about my personal experience very much. Had I been given, let us say, an hour and a half as opposed to 30 minutes max, I might have waxed lyrical about the legal history, not only of copyright, but of privacy and patents and all sorts of things. So yes, no, there's clearly a continuum of history. I think it's quite important that obviously the network doesn't engage with history at the expense of all else. All one is suggesting is that an awareness that there may be historical context that is relevant and helpful in pointing out either what, in fact, I remember the late Bill Wilson, whom I mentioned, saying in faculty meetings in Edinburgh, "We tried that 25 years ago. It didn't work then and it won't work now." That, you know, rather gloomy assessment can sometimes be beneficial in stopping one heading down a blind alley. The other thing about history in terms of influencing current opinion, though, is that people do remember things. You know, and if one talks about photocopying or home taping, whether it's film or sound recordings or whatever, that will correspond still, I think, to the youthful experience of the majority of our politicians and legislators, the people who are going actually to carry suggestions for development through. They will remember all that and they'll say, "Ah, yes, I remember how that issue affected me." And it does help you to communicate more effectively with a particular generation if you can tell them a story that they themselves can relate to. So I do think that's the kind of value I think that I'm pushing in what I've said tonight. Obviously, it's not a historical organization, and it's one that's going to look forward and try to take things forward. But my suggestion, my proposition is that in doing so, it should try and rest itself on a fairly secure awareness and knowledge of the recent past, at the very least, and as far back as Hinton and Donaldson, should anyone feel so inclined. It's easy to do it because all you have to do is read either Ian's article or mine, and you'll know all you need to know.
Thank you very much. One last question before moving on to the questions from the public. We have Janice Wong from St. Andrews University School of Computer Science.
Thanks so much, and thank you for your talk, Hector. It was really nice. Look at the history there, and kind of thinking about that history, particularly from last year. And you've talked about slightly the academic side and a little bit about the policy side and developments of legal history. But how do you think the relationship between law, technology, and the internet has changed for the general public? And how would that affect their perspectives, thinking about the way to move forward the next couple of years?
Well, my sense is that there's a continuity in that I think the general public loves the technology that's being made available to it. They lap it up. And they find new ways of using it that those who put the technology in place in the first instance had no idea of. So the public is completely engaged with the new technology, and I mean, I find it staggering actually. There's a wonderful cartoon, isn't there, somewhere where it's located in heaven or paradise. And there is this angel, I think, saying, it's a shame how all these people who've come in the 21st century go around looking sadly at their hands. Because, of course, in heaven, there's no need for the mobile phone. So, yes, that's a clear, observable phenomenon. And the thing that has struck me with ever greater force is just how indispensable these little things in our pockets have become to the way we live. So clearly the public loves technology. I think the main challenge is to find law that can regulate that technology where it needs to, without inviting immediate flaunting by the users of it out there. Because as I've said, I don't think there's anything you can do to control actual behavior. Once people find out a thing is possible, they will do it. The law will not prevent that activity. The question is the activity seriously antisocial, seriously problematic? And then and only then, I think, should it be regulated or even prohibited, and then it has to be enforced. It's a bit like the lockdown and what you can do out of doors. By and large, as far as I can see, the police haven't sought to enforce it because it would be so difficult to enforce in any meaningful way. But by and large, people have actually complied. So that balance between enforcing and getting compliance is an interesting one, and one that I think has to be kept in mind with technology just as much as it does with COVID-19 and restricting transmission.
So thank you very much, everyone. I think we can wrap up. I definitely learned a lot today, and it was great really to see how it is important to collaborate in the ways that the network intends to do, and that there is scope and need for sort of a Scottish initiative in this field. You can see the contact, the ways to contact us on using going to the website scotlin.org. Today, just before the event, essentially, I have changed on Twitter the birth date of the page of the network, and Twitter has automatically blocked me and locked me out because they said that I am a minor because I was born today as a network. So that's and I have just appealed. So that's an interesting case of algorithmic sort of accountability and the algorithmic society, etc. So I will let you know what happens, but normally you can follow the network on Twitter at Law Scottish, and or email us at scotland.network@gmail.com. Thank you everyone for thank you Hector in particular for your keynote. Thank you so much. Thank you Martin and Rosanna for the introductions. Thank you Arletta for the moderation. Thank you Jade, Torsten and Ian and Janice for the questions, and the public as well. Thank you very much. Goodbye.
Bye.